Can everybody hear me? Can y'all hear me okay? All right. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you are to go about reaching your decision, but now I simply want to explain how the trial will proceed. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charge is referred to as a presentment. The presentment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant has pled not guilty to the charges. She is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorney's arguments, and instructions of law, the 12 jurors seated in this case unanimously find the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if he should so choose. Again, statements of attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After you have heard all of the evidence, I will instruct you about the rules of law that you are to use in reaching your verdict. The final part of the trial occurs when the state and defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and help you understand the evidence that was presented. After you hear my instructions in the parties' closing arguments, I will select and excuse the alternate jurors, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application, you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against her. Thus, the defendant is not required to prove her innocence, to have her attorneys make any statements or arguments, or to produce any evidence. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. The conviction cannot be based on conjecture, suspicion, or mere belief that the defendant is guilty of the crime charged. Reasonable doubt is a high burden, but it does not mean proof of an absolute certainty. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the offense. Reasonable doubt does not mean a captious, possible, or imaginary doubt. A reasonable doubt is not a whim, it is not speculation or suspicion, it is not an excuse to avoid the performance of an unpleasant duty, and it is not sympathy. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the presentment. You must consider the evidence in each count separately. You must base that decision only on the evidence in the case and my instructions about the law. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each witness's testimony. In making up your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of the facts, such as the testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. Keep in mind that you may consider both kinds of evidence which are considered to be of equal value in the law. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or at some other location. If you do, perhaps the best standing rule is not to say anything. You also should not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. During the course of the trial, you will receive all the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not engage in any outside reading, visit any places mentioned in the case, or try to learn about the case outside of this courtroom in any other manner. I do know. There will be media reports in the newspapers, on TV, or on the radio about this case. You are not permitted to read, watch, or listen to those reports. You, as jurors, must base your decisions solely on the evidence you hear in the courtroom. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence. You must decide the case on the evidence presented to you. However, during the course of the trial, I may ask a question or two of a witness. If I do, that does not indicate that I have any opinion about the facts in the case or that I have any opinion with respect to that witness's credibility. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing, and in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I ask your patience because these interruptions are necessary points in the trial where we have to resolve legal issues. If, after your deliberations, you find the defendant guilty of first-degree murder, we will then proceed to a sentencing and you will set the punishment. If, after your deliberations, you find the defendant guilty of any other offense or offenses, the court will set the punishment in a separate sentencing hearing. The jury will not be involved in setting the punishment in those offenses. This completes my opening comments to you. We will now proceed with the reading of the presentment. General.
Thank you, Judge. Presentment, case number S-72-869, State of Tennessee, County of Sullivan. Criminal court, charge, first-degree murder, count 1. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully, feloniously, intentionally, and with premeditation kill Evelyn Mae Boswell, contrary to Tennessee Code annotated section 39-13-202A1, and against the peace and dignity of the state of Tennessee, signed Barry P. Staubus, District Attorney General. Charge, felony murder, count 2. The grand jurors for Sullivan County, Tennessee, being duly impaneled and sworn, upon their oath present and say that Megan Boswell, on or about December 2019, in the state and county aforesaid, and before the finding of this presentment, did unlawfully and feloniously kill Evelyn May Boswell, a human and being, said killing being committed in the perpetration of or attempt to perpetrate the felony crime of aggravated child abuse, contrary to Tennessee Code Annotated Section 39-13-202A2, and against the peace and dignity of the state of Tennessee. Signed, Barry.